సమాజపు మలుపు అన్నా ఓ మా లాయరన్నా నీ మనసెంతో వెన్నన్నా కావాలన్నా మీరు సమాజానికి మార్చాలన్నా ఈ సమాజాన్ని కావాలన్నా మీరు సమాజానికి మార్చాలన్నా ఈ సమాజానికి నమ్మి వచ్చినోళ్లకు నమ్మకమే మీరన్నా నమ్మి వచ్చినోళ్లకు నమ్మకమే మీరన్నా మా కంటి నీటిని తూర్చే మా కంటి నీటిని తూర్చే కను పాపే మీరన్నా అన్నా ఓ లాయరన్నా అన్నా మా లాయరన్నా మీ మనసెంతో వెన్నన్నా మీ మనసు కడుపులో బాధలెన్ని ఉన్నా నీట్ల ఇంటూ బాధనే మీదనుకుంటావన్నా కడుపులోన నీకు బాధలెన్ని ఉన్నా నీట్ల ఇంటూ బాధనే మీదనుకుంటావన్నా మోయలేని బాధలు నీ మనసులోనే ఉన్నా మోయలేని బాధలు నీ మనసులోనే ఉన్నా న్యాయం వైపే నీ అడుగుంటదన్నా న్యాయం వైపే నీ అడుగుంటదన్నా నమ్మి వచ్చినోళ్లకు నమ్మకమే మీరన్నా నమ్మి వచ్చినోళ్లకు నమ్మకమే మీరన్నా మా కంటి నీటిని తూర్చే మా కంటి నీటిని తూర్చే కను పాపే మీరన్నా అన్నా ఓ లాయరన్నా అన్నా ఓ లాయరన్నా నీ మనసెంతో వెన్నన్నా అన్నా ఓ లాయరన్నా నీ మనసెంతో వెన్నన్నా. ఇది నేను నిన్న రాగానే ఎందుకో మిమ్మల్ని అందరిని చూసి పాట రాయాలనిపించి 2 నిమిషాలల్లా ఈ పాట రాయడం జరిగింది. ఇంకో 2 చరణాలకు తప్పకుండా ఈ పాటను పూర్తి చేస్తా. అయితే నేను పాట రాసేటప్పుడు ఎవరైనా రచయిత పాట రాసేటప్పుడు భయపడతారు. ఎందుకంటే చిన్న చిన్న తప్పులు ఏమైనా ఉంటే ఏమైనా కేసు పెట్టి జైలు వేస్తారేమో అని చెప్పేసి భయపడతారు. కానీ నేను ఈ పాట రాసినప్పుడు భయపడలే. ఎందుకు భయపడలే అన్నప్పుడు ఇంతమంది లాయర్లు ఉన్నాక నేను భయపడితే నన్ను జైలు వేసి తీసుకురావడానికి వీళ్ళందరూ ఉన్నారు కదా, అందుకే భయపడకుండా ఈ పాట రాసిన. కాబట్టి అవకాశం ఇచ్చిన మీ అందరికీ ప్రత్యేకంగా ధన్యవాదాలు తెలియజేస్తూ, కాబట్టి ఇంకొక అవకాశం ఉంటే థ్యాంక్ యూ థ్యాంక్ యూ సో మచ్. మళ్ళీ అవకాశం కల్పించిన మీ అందరికీ మళ్ళొకసారి ధన్యవాదాలు తెలియజేస్తూ, తూర్పు తెల్లవారుతుంది ప్రతిదినం కాలం గతి మారుతుంది ప్రతి క్షణం ఓ ప్రతి క్షణం తూర్పు తెల్లవారుతుంది ప్రతిదినం మంచి మార్పు లోకానికి మంగళదాయకం మంచి మార్పు లోకానికి మంగళదాయకం అది వికటించిందా అభ్యుదయ వినాశకం తూర్పు తెల్లవారుతుంది ప్రతిదినం కాలం గతి మారుతుంది ప్రతి క్షణం ఓ ప్రతి క్షణం ప్రవహించే నీటికి ఏ కులమున్నది ప్రసరించే గాలికి ఏ మతమున్నది ప్రవహించే నీటికి ఏ కులమున్నది ప్రసరించే గాలికి ఏ మత కులం పేర మతం పేర జరిగే కలహాలు, కులం పేర మతం పేర జరిగే కలహాలు, మనిషిని పశువుగా మార్చే విషవలయాలు. తూర్పు తెలవారుతుంది ప్రతిదినం, కాలం గతి మారుతుంది ప్రతిక్షణం, ఓ ప్రతిక్షణం. ఎవరు తిండి వారు తింటే స్వార్థం కాదు, ఎవరు ఇంట వారుంటే ద్వేషం లేదు. ఎవరు తిండి వారు తింటే స్వార్థం కాదు, ఎవరి ఇంట వారుంటే ద్వేషం లేదు. పరుల నోరు కొడితే అది పైశాచిక తత్వం, పరుల నోరు కొడితే అది పైశాచిక తత్వం. ఎప్పుడయ్యా తెలిసేది ఈ మౌలిక సత్యం? తూర్పు తెలవారుతుంది ప్రతిదినం, కాలం గతి మారుతుంది ప్రతిక్షణం, ఓ ప్రతిక్షణం. తూర్పు తెలవారుతుంది ప్రతిదినం, ఓహో థ్యాంక్ యూ మీ అందరికీ ధన్యవాదాలు.
ఈ యొక్క వానతోటి మనం ఎంతో ఈ ఎండల్లో ఇబ్బందులు పడుతున్నాం. దానికి సంబంధించి నేను రాసినటువంటి వాన మీద పాట. నేను కాంతయ్య గడిదేసి భద్రాద్రి కొత్తగూడెం జిల్లా నుంచి నేను రావడం జరిగింది. నేను AILU జిల్లా ఉపాధ్యక్షుడు. నీయలక ఏమిటి మా వంక చూడవి, నీయలక ఏమిటి మా వంక చూడవి. నింగిలో నీలి మేఘం కనుచూపు మేరలేదు, అది చూసి ఎడవాలన్నా కళ్ళల్లో నీళ్లు లేవు. నింగిలో నీలి మేఘం కనుచూపు మేరలేదు, అది చూసి ఎడవాలన్నా కళ్ళల్లో నీళ్లు లేవు. గొంతెండి నోటిలోన ఏ చేటి రాగం లేదు, కనిపించే ఎండమావు జగదాలి చేసే చూడు. ఓ వాన ఓ వాన నీ అలక ఏమిటి మా వంక చూడవి. వారు వంక నీ వంక కొట్టిపోయి చూస్తున్నాయి, పశుపక్షాదులని ప్రాణ విధితోలున్నాయి. వారు వంక నీ వంక కొట్టిపోయి చూస్తున్నాయి, పశుపక్షాదులని ప్రాణ విధితోలున్నాయి. చేను చెలక నీళ్లు లేక గుండె పగిలి చస్తున్నాయి, నీవు లేక పుడుమ తల్లి బుద్ధి బాధలు చూడవా. ఓ వాన ఓ వాన నీ అలక ఏమిటి మా వంక చూడవి. నీలకై నీమంతా కటకటలాడుతుంటే కైలాస శివునితో చిందులు వేస్తున్నావో. నీలకై మేమంతా కటకటలాడుతుంటే కైలాస శివునితో చిందులు వేస్తున్నావో. మా గుండె అగక ముందే మా ముసులు తగలక ముందే నిగిరి నేల చేరి నన్ను కాపాడమా.
పాడుదమా స్వేచ్ఛా గీతం ఇదరేయుదమా జాతి పతాకం. పాడుదమా స్వేచ్ఛా గీతం ఎగరేయుదమా జాతి పతాకం దిగంతాలని నదించి విశ్వవిఖ్యాతి నందగా జాతి గౌరవం పాడుదమా స్వేచ్ఛా గీతం ఎగరేయుదమా జాతి పతాకం జలియన్ వాలాబాగు నెత్తుటి ధారల నత్తుకొని ఉరి కొయ్యల చెరసాల గోడల దారుణాల తలనెత్తుకొని జలియన్ వాలాబాగు దురంతపు నెత్తుటి ధారల నత్తుకొని ఉరి కొయ్యల చెరసాల గోడల దారుణాలు తలనెత్తుకొని పొగిలిన కాలం పోరాడిన కాలం మరి మరి ఒక పరి తలుచుకొని మృత వీరులని కొలుచుకొని పాడుదమా స్వేచ్ఛా గీతం ఎగరేయుదమా జాతి పతాకం వందే మాతరమని నినదించిన వీరుల శౌర్యం నిలదుకొని స్వాతంత్ర్యమే నా జన్మ హక్కని గర్జించిన గడవందుకొని పోరాట ఫలం స్వాతంత్ర ఫలం కలకాలం కాపాడుకొని కడుగర్వంగా కొడియాడుకొని పాడుదమా స్వేచ్ఛా గీతం ఎగరేయుదమా జాతి పతాకం జనగణ మనముల జాగృతి నింపిన జెండా గాథలు చెప్పుకొని జయ 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 హే జననీ అని జయ గీతములు పాడుకొని పావన చరితం పరిమళ భరితం అఖండ భారత ఖండమని అది అక్షయ పంపుత భాండమని పాడుదమా స్వేచ్ఛా గీతం ఎగరేయుదమా జాతి పతాకం పాడుదమా స్వేచ్ఛా గీతం ఎగరేయుదమా జాతి పతాకం.
Dear delegates and officers, 2 నిమిషాల్లో సమావేశం ప్రారంభం కాబోతుంది. ముఖ్య అతిథి కూడా విచ్చేశారు. దయచేసి తమ తమ సెల్ ఫోన్లని సైలెంట్ మోడ్లో పెట్టుకోవాల్సిందిగా కోరుతాము.
ఓకే గెస్ట్ రాగానే ఆపేయాలి 30 రాగానే
All of you, good morning, sir. Delegates, దయచేసి ఎవరి స్థానాలలో వారు ఆసీనులు కావాల్సిందిగా కోరుతా ఉన్నాం. ఒక 2 నిమిషాల్లో సమావేశం ప్రారంభమవుతుంది. దయచేసి వారి యొక్క సెల్ ఫోన్లని సైలెంట్ మోడ్లో పెట్టుకోవాల్సిందిగా విజ్ఞప్తి చేస్తాం.
I request all the delegates to take their places and let us start the program. I request all the people to look at the right side of this dais. I request all the people who are on my right side to take their chairs, respective chairs there. Please vacate the place. Good morning, gentlemen and madams. I take privilege of inviting all of you to this seminar organized on the eve of the 3rd State AILU conference. And from yesterday, about 300 delegates are participating in this conference and deliberations are being taken place. And you have witnessed yesterday's program where Hon'ble Sri Justice P. Sudarshan Garu, retired Supreme Court Judge, and Sri Justice K. Lakshman Garu, who have addressed all of you and enlightened us on constitutional issues as well as practical issues. And today we have invited His Lordship Sri Justice Ujjal Bhuyan Garu, the Chief Justice of Telangana, to address all of us based on the constitution and the courts. I humbly request our President Sri Vijaysagar Garu to come on to the dais and to preside over the today's seminar. As advocates, we all know that today it is the High Court of Telangana which is heading the judiciary here, and now Sri Justice Bhuyan Garu is taking care of the institution, judicial institution. And on behalf of AILU, we submit and request the Honorable Bhuyan Garu to see that the recent bifurcation of judicial districts of 33, there is lack of buildings, infrastructures, and non-availability of the judicial officers. And in majority of the courts, district courts, there are no regular official courts, because except one or district court and additional district court, the special courts like SCST court, POCSO courts, and the special women special courts, likewise, the designated courts are not being allocated to the respective districts. So on this occasion, I do request the Honorable Sri Justice Ujjal Bhuyan to take all these things, because we know that he is so active. And the day before yesterday, we have witnessed a judgment comment basing on a writ petition which was filed. He is a person who is interested in social justice. The day before yesterday's comment was passed, that sweeping comments are going to show that how best he is concerned about the constitution and the foods which are to be reached to the common public. So we humbly appreciate, it's not appreciation, but we say humbly thankful to you, sir, because you are trying to uphold the constitutional values in Telangana state. Now I request Sri Justice Bhuyan Garu to come and occupy his chair. We all know that the bar and bench are the two wheels of a chariot, and now the bar council, AILU bar organization is also involving the judiciary as well as the bar, which is headed by our beloved chairman Sri A. Narasimha Reddy Garu. He is leading the Bar Council of Telangana, and he is now becoming the first advocate of the state. So I request Sri A. Narasimha Reddy Garu to come and occupy his chair. I request Sri P.V. Surendranath Garu, our All India Secretary, who has come all the way from Delhi to conduct the proceedings and also to guide us. And I request Sri P.V. Surendranath Garu, All India Secretary, AILU, to come and occupy his chair. And I take the privilege of calling upon the reception committee chairman, Sri Nagam Anjay Garu, President Bar Association Bhuvanagiri, because he along with Ismail and all other members of the Bar Association Bhuvanagiri has taken it as a prestigious occasion of Bhuvanagiri Bar Association. So I request. And now it is my turn. I will occupy my chair, but before leaving the podium, I request Sri Chandrasekhar Azad Garu to come and offer a bouquet to Sri G. Vidyasagar Garu. These are all formalities I have to follow. Time is running out, so I request the advocates to be fast in presenting the bouquets. I request Mr. Ismail, Secretary Reception Committee, to come and offer a bouquet to our Honorable C. Justice Ujjal Bhuyan Garu. I request Mr. A. Shankaraya to come and offer a bouquet to our National Secretary, Sri P.V. Surendranath. I request Srimati Manjula Garu to come and offer a bouquet to our Reception Committee Chairman, Sri Naga Manjay Garu. Before leaving the podium, I would like to recollect yesterday's comments made by our High Court as well as the retired Supreme Court judge with regard to the participation of women. I feel very happy of having such a huge number of lady advocates as well as judicial officers among us, and we are proud to say that our Chief Justice has also made her better off to be part of this seminar. So we invite her also to this seminar. Thank you, madam, for coming over here. Now I request Sri Abagani Venkateshwarlu to offer a bouquet to our Bar Council Chairman, Sri Ananda Reddy. Before commencing the session, I request Srimati Shailaja, Women Advocates Committee convener, to offer a bouquet to our Madam Srimati Ujjal Bhuyan.
So now I request one bouquet for our General Secretary, Kuli Satyanarayana Garu.
It is privileged to hand over the Constitution of All India Lawyers Union, because yesterday I also explained, because our AILU is running based on Constitution, written Constitution, and I would like to hand over the written Constitution of AILU to your Lordship Sri Ujjal Bhuyan Garu and also the Chairman Bar Council. I request the President Sri Vidyasagar Garu to continue the proceedings.
Sir, can no other back seat, please.
I complete the formalities of the and requesting AS and Ramchandra Reddy to hand over the bouquet to Koli Satyanarayana. Good morning, everyone. Although there was a delay in starting the proceedings, my Lord the Chief Justice Ujjal Bhuyan, who has been the champion of the social justice, and the day one he came to our High Court, and after assuming his charge as a Chief Justice on 28th June 2022, almost we are 1 year we have been witnessing. There is a lot of change in our atmosphere in our High Court and the judiciary in the state. So it's the head of the institution which makes a change, which gives a vision how to proceed, how to conduct ourselves. The manner in which he conducts the court proceedings have been of higher excellence because I have been practicing for the last 25 years in High Court. And he accommodates everybody and encourages the junior advocates in the court. And he is the first Chief Justice who has introduced the live court proceedings in our High Court. And it has become a mark in the entire country. Now all the Chief Justice courts in the countries, now they are following our tradition of having a live telecast of the court proceedings. We are grateful to you, sir, for having it. And he has also been, as we were informed, that he has also been asking the other judges also to follow wherever it is not possible for an advocate to physically come to the court and to have a virtual mode of hearing also. In fact, His Lordship Chief Justice, even before the live telecast has permitted, one of the counsel who was at Delhi who could not come over, he accommodated that advocate that even at 4 o'clock after 15 minutes before the court proceeding, he started the video conference and conducted the court proceedings. That shows the immense, his attention towards the dispensation of the justice. I may inform you that his father was one of the senior designated advocate of the Guwahati High Court. Later he became the Advocate General of the Guwahati High Court. That shows that they have a tradition from his father also. And the moment he came to the Hyderabad from Mumbai, we could see the change in the attitude of the conduct of the proceedings. In fact, I had an opportunity when he came to the High Court of Telangana on transfer. First day I moved a lunch motion before the then Chief Justice and Justice Bhuyan. I was hesitant to move a lunch motion because the first day he was holding the court in High Court at Telangana, Hyderabad. He gave me the lunch motion. Then he also granted me an interim order, which was helpful to a student to continue the studies in the MBA. Millard, our All India Lawyers Union has been, as you lordships are aware, has been in the existence since 1982. Justice Krishna Iyer and many other stalwarts have thought fit to organize an association for the advocates so that we are not parallel to the Bar Council or Bar Associations, but we wanted to ensure that the advocate community are benefited, and in the process we will also be serving the humanity. Social justice is our aim, and as my friend Satyanarayana has given the constitution of our All India Lawyers Union, we uphold the constitution. We want to ensure that the constitution is upheld and advocates are ensured that they give the utmost services to the downtrodden and the poorest of the poor of the country. We have been conducting various courses, various programs for the advocates so that they will be in a position to discharge their duties as an advocate and help the needy citizens. For the yesterday onwards, we have been conducting our seminar. Our first conference after the formation of the Telangana was in Khammam, then second was at Warangal, third at Bhongiri. I do not want to prolong further because there are many, I understand there is a delay on our part in conducting the program. Before I call upon Hon'ble Chief Justice to speak on the topic, I request Sri A. Narasimhareddy Garu, Bar Council Chairman, to address the conference.
President of the function, Sri G. Vidyasagar Garu, Senior Counsel. Today's Chief Guest of function, Honorable Chief Justice, Sri Ujjal Bhuyan Garu and Madam Ujjal Bhuyan Garu. My esteemed brother member of Police of Bar Council of Telangana, Sri Police Satyanarayana Garu, and Vice Chairman Sunil Gaur Garu, and Sri P.V. Surendranath Garu, General Secretary of India Lawyers Union. N. Njay Garu, President, Bar Association, Bhuvanagiri. MD Ismail Mohammed, my esteemed brother members of Bar Council, respected senior councils, respected judicial officers of this area, distinguished invitees of the dais, my dear advocate brothers and sisters. At the outset, I would like to congratulate All India Lawyers Union for conducting this 2 days conference to debate and discuss several issues pertaining to the day-to-day legal practice and also to update the knowledge of younger generation of legal profession. I would like to share this distinguished gathering some of the issues which are debated by the legal experts, the media and general public. As we know, and also it is heartening to know that there is a general appreciation of the recent trend of the judicial activism in our country. Especially, as my friend said, Vidyasagar Garu, especially coming to our state also. The failures of the government in various fields have been exposed and have been addressed with the intervention of judiciary. This has undoubtedly kindled the hope of common man in the state so far as the working system of judiciary in our state. The public impact of the legal profession, because as we are here to discuss subject, but my Lord Chief Justice is there to elaborately explain about the subject. Coming to day-to-day practice and some of the important aspects I wanted to bring to notice of this gathering. The public impact on the legal profession can be gathered by the observation of Supreme Court in All India Judges Association versus Union of India, wherein it was expressed that the administration of justice and the part to be played by the advocates in the system must be looked into the point of view of litigant public and the right to life and liberty guaranteed under the Article 21 and a right to grant legal aid as contemplated under section under Article 39A of the Constitution. This is very, very important according to me. This aspect of the advocate as a public servant is closely tied to the fact that the key role he plays in the development and also dispute processing activities and above all in the building of a society and also in maintaining the constitutional order so far as the judicial process. This character of the legal profession entails certain high traditions which its members are expected to upkeep and uphold. Therefore, the lawyers plays an indispensable role in the mechanism of administration of justice. However, the lawyer has a particularly onerous and multi-dimensional role to fulfill it, as expressed by the Justice Matthews. I quote his words. A council has a tripartite relationship, one with the public, another with the court, and also the another with his own client. This is unique feature in this legal profession. Speaking about the role of lawyers, Lord Denning had expressed view in the following words, I quote, as an advocate, he is a barrister or whatever it is. He is the Minister of Justice equally with the judge. The lawyer as a class has an obligation to see that the rule of law is maintained. A lawyer is a better upholder of law on all occasions, in all circumstances, and at all times. It would not be out of place to mention that a lawyer is a man of all seasons. Why I am saying this? Keeping in view of this administration of judiciary and also constitution, everything we are part of it. That's how my friend just now Kulsatanagar said. Not a mere saying that bench and bar are two wings. Really, so many aspects like that. First Advocate General, you may be knowing, that Motilal Setalwar, he specifically said one aspect, and he himself was praised by Hon'ble Chief Justice of India, Merchant Mahajani, at one meeting. The Setalwar was a jurist of international reputation and used to pay quite often that no welfare state, he used to say, no welfare state can flourish and effectively function unless there is an administration of justice and sine qua non, for the same is closest to cooperation between the bar and bench. Without there is a relationship, close relationship bar and bench, absolutely it's not possible to get proper justice, and also administration justice will fail according to me. Friends, one thing, I don't want to take much time, but my relation with the All India Lawyers Union, when in the year 1995 when I elected as a member of the Bar Council, thereafter I become vice chairman, thereafter 2006 I become chairman of the Bar Council. In all stages, my platform is only All India Lawyers Union. Because when I enter into the profession, my Lord Chief Justice should know, Telangana, so for Telangana, 1 or 2 or 3 or 4 judicial officers were there. When I have been to Kurnool, that is Rayalaseema, to attend some seminar conference, along with the Honorable Justice Singhi Garu, so nearly 25 officers were sat in one place. When I inquired, sir, why you are waiting like this? No, sir, we are all belongs to Kurnool. I surprised and shocked. Mayavada district, there is no 2 or 3 officers. The North Telangana, only Mayavada district. When I started thinking how to meet this challenge, because I personally I wanted to motivate the advocates to go for judicial officer test. Then I approached my good friends, Dasar Garu and Kulsatanagar, who planned for moot courts and moot examinations, preparation of the exams for the candidates who are interested. Really, their service is wonderful from the beginning. They supported. So far, on behalf of the Bar Council, always has to be there with them. One instance I wanted to tell Mela, and I'll close my this thing. So 2008, I think, there was a national conference by the All India Law Conference. My friends asked me to be there as a chairman of reception committee. I was being a chairman of reception committee when we wanted to inform one of the reputed judge from Supreme Court. Justice Jeevan Reddy, some other judge, they suggested, why don't you invite Sivaraj Patil from Karnataka? He's the very best person to suit your purpose. So we tried and we invited him. On the day of inaugural function, as a reception committee chairman, I started telling that Sivaraj Patil Garu is a very reputed judge from Karnataka, retired Supreme Court judge. He might have delivered a number of the landmark judgment. After my speech, he started saying, that's why he said so many things, including I might have delivered a number of judgments. But he said, brother, number of judgments are there, but very few judgments are for my satisfaction. Like that, he has given detailed examples. Only from this platform, I request Honorable Chief Justice, as said by my friend Vidyasagar Garu, from the beginning, we have hope after our Chief Justice took responsibility of even second position, Chief Justice also. We have a hope on behalf of the litigant public. Definitely there will be justice. Recent trend also going toward that everybody, including common person, even educated person, advocates, we have hope on the judiciary. Definitely, this will be done, and we are fortunately in different positions to support the system. Thank you, one and all.
Sir, thank you, Narasimha Reddy Garu. As you were saying, always he has been supporting our All India Lawyers Union organize. Whenever we organize any function or any meeting and conference, he is the first man to say, yes, I am behind you. Thank you for giving every time support to our All India Lawyers Union. Now I request, before Honorable Chief Justice, I request Mr. Surendra Narak, General Secretary, All India Lawyers Union, to speak a few words.
Honorable the Chief Justice Ujjal Bhuyan, all other respected dignitaries, judicial officers, delegates, my dear friends, I won't grab your time. I am here to hear the words of the Chief Justice Ujjayan ji. I only mention one thing. Chief Justice, though one among the equals, number one among the equals, he who sets the tone and tenor of the entire judiciary of the state. And I am happy to know, though I have no personal interaction with Chief Justice, from the nice words, I understand that the correct right tone and tenor is set already by Honorable the Chief Justice. So I am here to hear the words of Chief Justice. So without saying anything about the subject, only mentioning only one fact, that is, the role of judiciary is as an independent arbiter whenever there is conflict between the formal aspects of democracy and the substantial aspects of democracy. There should be a touchstone for that, and that is our constitution. So I am sure that it will be elaborated by Chief Justice. So I am here to hear the words. Thank you, thank you.
Thank you, Surendra Garu. Now I request Honorable Chief Justice Ujjal Bhuyan Garu to address on the topic Constitution and the Judiciary. Yesterday we had a talk on the Constitution and the role of advocates. Now the Judiciary part and the Constitution, Honorable Chief Justice will be addressing us.
Mr. Vidyasagar, Senior Counsel, Mr. Narasimha Reddy, Chairman Bar Council, Mr. Surendra, National Secretary of All India Lawyers Union, Naga Manjaya, Chairman of the Reception Committee, Mr. K. Satyanarayana, General Secretary, All India Lawyers Union, and also member of the Bar Council, Madam on the dais, Mr. Vela Bhaskar Rao, Principal District Judge, and the judicial officers who are present here, Mr. Sunil Gaur, Vice Chairman, Bar Council, Mr. Chikudu Prabhakar, a regular member of the bar who practices in my court, and the large number of my lawyer friends who have assembled here from different parts of the state of Telangana. A very good morning to all of you. At the outset, I must confess that though I am in my 12th year as a judge, I am still a lawyer at heart. And sometimes I even act like a lawyer, because then I have to pull myself back sometimes. Once a lawyer, always a lawyer. I believe that. And whatever I am today, whatever position I have reached today, it is because of the training that I have received at the bar. The training that is, it is a life school actually. The bar is a life school. The training that we get at the bar not only helps us in becoming a good lawyer, helps us in becoming a good human being, and will help us in the life ahead. So thank you very much for inviting me here. I remember, I think my father was also associated with the All India Lawyers Association. Of course, when he was a young student, he was a firebrand student leader. He was inspired by Mr. EMS Nambudipad and many others that and in fact, he had gone underground as a young student, and the police had put up some during the last phase of the British rule. Some prize was also that if you any information, you will be given this much of money. Then when India became independent, I think he was a member, card-holder member of the Communist Party, and the Communist Party was proscribed at that point of time, and he was taken into custody. And when the ban was lifted, he was released. He met my mother in the jail, Nagaon jail, that's the jail. And later on I come to know that they got married on 26 January 1950. What a coincidence it is. So, his teachers, after he came out of imprisonment, his friends had already passed out from the university. They had already started occupying different positions. Some had become teachers also. So when he resumed studies, they were in fact teaching. So some of his teachers said that since you have good oratorial skills, why don't you try for law? And that's how he studied law. And he joined the chamber of Mr. Fakhruddin Ali Ahmed, who was then a leading barrister in Guwahati in those days. And during those days, there used to be what is called article clerkship, not like today we have. You have to become an article clerk of in a chamber, whereafter, after completion of the course, you will be tested by the full court. And the full court will certify you. Thereafter, your license is given to practice law. So he joined the chamber of Fakhruddin Ali Ahmed, but midway, because of political reasons, he went on to join the Assam Ministry as the Finance and Law Minister. So he was left high and dry. Then he went on to the next year. Ultimately, he completed in 1958. He was granted license to practice law. This is how he started his practice. I remember those early days, he used to come back home from court, tell us different stories, anecdotes, what happened in court, what are debates which happened in court. 77, I'll come to that. The emergency was declared, and at that time the Home Minister of the state was Mr. Hiteshwar Saikia. Many of you may have heard of him. There was an allegation that he had committed atrocities during the emergency on the students, particularly the university students. So, Guwahati University is on way from the airport to the city. So after the emergency was lifted, the new government had come, both at the center as well as the state. An inquiry commission was appointed to go into the excesses committed during the emergency. On behalf of the citizens, on behalf of the others, my father had cross-examined severely for several days the then Home Minister, Mr. Saikia. Not only that, Saikia's election was challenged in the High Court on various grounds, and the lawyer representing the election petitioner was my father. Unfortunately, various other events took place. 78, 79, the Assam movement for expulsion of foreigners overtook the state, and the 83 elections were boycotted. There were a lot of bloodshed. Hiteswar Saikia became the chief minister of the state of Assam. He wanted an advocate general. He did not go to a congressman or any political reason. He came to my father. He requested my father, and my father became the advocate general in 1950. So I am only saying this, that nowadays these constitutional posts are also, appointments are made for various other reasons. But this is an instance where both showed exemplary, statesman-like approach in appointing a person who was his legal adversary as his closest advisor, legal advisor. So I'll put it at that. Friends, thank you for inviting me to your midst today. As I said, I feel very comfortable and very happy when I am in the midst of lawyers. 1947, 15th August, we became independent. A constituent assembly was set up. And that constituent assembly, there was a drafting committee. They debated. Ultimately, they framed the draft constitution of India. And ultimately, on 26 November 1949, it was adopted, having 395 articles, and which came into force on and from 26 January 1950. Professor Granville Austin, one of the renowned scholars of Indian constitutional law, has defined Indian constitution to be first and foremost a social document. It is, of course, no doubt a political document, but first and foremost, it is a social document, the primary objective of which is to build a democratic and equitable society. Well, friends, if you look at the Constitution, yesterday Justice Sudarshan Reddy read before you the preamble. If you look at the Constitution of India, perhaps even the articles like Article 14, these are even today way ahead of our times. If this is what we feel today, that it is way ahead of our times, what it could have been when we became newly independent in 1947. So great the foresight of our founding fathers, led by the great Baba Saheb Bhimrao Ambedkar, the great foresight they have shown, and the cornerstone of the Constitution. If you ask me in one word, the essence of the Constitution is equality. This is the essence of the Constitution. Equality between men and men, equality between men and women. This is our basic essence of our Constitution. Friends, one of the first cases which came up before the Supreme Court during the early days was the case of Mr. A.K. Gopalan versus State of Madras. Gopalan was a communist leader of then the province of Madras, and he was arrested under the Preventive Detention Act of 1950. This was challenged before the Supreme Court. The challenge was made primarily on the ground that this preventive detention is violative of Article 14 because it is arbitrary. It is violative of Article 19(1)(e) because by putting me in prison, it has curbed my freedom of speech and expression. It is violative of my freedom to move freely in throughout the country. Therefore, it is violative of 139(g). It is also violative of Article 21 because it deprives me of my right to life and liberty without there being a fair procedure. The contention was that this challenge 14, 19, 21 would have to be read together and the detention order would have to be adjudicated accordingly. The other contention was that the law depriving a person of his life and liberty should not only be a written law providing for a procedure, that law must prescribe, it must be a fair procedure. In other words, it must be a procedure which is in conformity with the principles of natural justice. It was nascent days, early days of our republic. Perhaps the arguments advanced were too ahead of the times. It was not accepted by the majority. Majority said this concept of natural justice is too nebulous. We cannot read these type of concepts into our constitution. Secondly, the majority held that 14, 19, 21, or for that matter different articles of the constitution are in different compartments. These cannot be juxtaposed with each other. In other words, these were separate compartments and the challenge would have to be tested on the anvil of each article. The minority view of Justice Fazal Ali said that no, each article is not a watertight compartment. There are no clear-cut demarcation like that. And challenge like this would have to be tested on the anvil of all the articles read together. It is like a body having a whole, body as a whole. You cannot separate different organs of the body and then try to revive a person. Then the important thing is that he held that not only there must be a law and the law prescribing a procedure whereby your right to life and liberty can be curtailed, but that law must be a fair law. That law must be a law which is in conformity with the principles of natural justice. But that was the minority view. As we shall see, the force of law is always with the majority, but it is often said that the wisdom lies in the minority viewpoints. Justice R.F. Nariman recently, he has published 2 volumes of all minority judgments of the Supreme Court right from the beginning till date, till the time he was in the Supreme Court. And you will be surprised to know that majority of the dissenting or the minority views are by Justice K. Subba Rao from this court, who went on to become Chief Justice of India in the 50s and 60s. So this is how it was in 1950, A.K. Gopalan's case. And it remained like that for a long, long time. Now on the administrative side also, certain interesting developments have taken place. The then Prime Minister of India, Mr. Nehru, it appears, he did not have a good equation with Justice Mahajan. Maybe because of their, both were from Kashmir, and because of political reasons, he did not have a good, favorable opinion about Justice M.C. Mahajan. So when Patanjali Shastri was about to retire as Chief Justice of India, he approached or he sent a word to Justice Bijan Mukherjee that the government of India is inclined to make you the Chief Justice of India, superseding Mr. Mahajan. Would you accept that proposal? Mr. Justice Mukherjee said that this is the last thing that I will do. I will wait for my time. If you try to supersede me, not only me, all the judges of the Supreme Court will resign. So, Justice Mukherjee waited for this term. Mahajan became the Chief Justice of India. And when he demitted office on 22nd December 1954, then Justice Mukherjee became Chief Justice of India. So these are great men adorning the offices of the Supreme Court. Because of these great men, and of course women, brick by brick, they have built the edifice of our judiciary, the Supreme Court, and which has stood the test of time. Friends, we have seen thereafter a number of cases, important cases, overtook our country. One of the cases was Goloknath versus State of Punjab. Certain agricultural reforms were brought in by Union of India, but Supreme Court struck down those constitution amendments, saying that you can amend the constitution, but you cannot amend the fundamental rights in the constitution of India. So this is Goloknath. Goloknath was by 6:11. By that time, it was 11 judges on a particular bench, and that was the highest bench in the Supreme Court. 6:5. And this Goloknath case was of 1967. It was followed by the bank nationalization case in 1969. 14 private banks of the country were nationalized by the government of India. And in lieu of nationalization, certain bonds were given. This was challenged. R.C. Cooper versus Union of India. It is a landmark case, landmark judgment. Supreme Court upheld the right of the Parliament to nationalize the banks, law for nationalization of the banks, but said that the compensation has to be adequate. It cannot be inadequate. So this is the R.C. Cooper's case. Interestingly, in R.C. Cooper, Supreme Court held that these fundamental rights, 14, 19, 21, are not watertight compartments. They cannot be looked at in isolation. They have to be looked together. So one portion of the judgment in A.K. Gopalan's case was reversed in R.C. Cooper after almost 20 years. Then we had to wait for some time. Of course, the next year itself, 1970, the government of India abolished privy purses of the princely states. The privy purses were abolished. This was challenged, incidentally, by Madhav Rao Scindia as the petitioner, the father of Jyotiraditya Scindia. He challenged this on the ground that this is in violation of the solemn assurance given by government of India, the Home Minister Patel, Vallabhbhai Patel, Sardar Patel, to the princely states that they would be given private purses in lieu of their states merging into the Union of India. Of course, this abolition of private purses was also to a limited extent interfered with by the Supreme Court. Interesting to note, in all these cases, the petitioners were represented by the great Nani Palkiwala from Bombay. So he was the common thread in all these writ petitions, in all these cases, which were argued before the Supreme Court till that point of time. So suffering one setback of the other and one setback after the other, the government of the day brought in a series of amendments to the Constitution. Those were to be challenged now. So people were searching for a suitable petitioner to challenge these amendments which were brought in from the government of India. Ultimately, the petitioner could be traced to the state of Kerala from where Mr. Sundarnath belongs. His Holiness Keshavananda Bharati was found, and he became the petitioner in one of the most leading constitutional cases of the country, Keshavananda Bharati versus Union of India. At that point of time, headed by the bench was headed by Chief Justice of India, S.M. Sikri, and it had the largest composition of 13 judges. 13 judges sat on the bench of the Supreme Court. It was heard, headed by Chief Justice S.M. Sikri. And it is said in his book, Mr. Fadi Nariman has written, before memory fades, how the judgment was delivered. Andhya Rujina has also written a book giving a ringside view of how things unfolded in this case. It was one of the great cases argued by Mr. Palkiwala. Ultimately, on the eve of his superannuation retirement of Justice S.M. Sikri, the judgment was delivered. There are a lot of criticism here again. They said that so many judgments, individual judgment, opinions were delivered. It was very difficult to find out what was the ratio. But ultimately, what is said that it is this judgment which upheld the principle or theory of basic structure. It means that you can amend any portion of the Constitution, including the fundamental rights. Thereby, Goloknath was overruled. But you cannot, by exercising the power of amendment, destroy the Constitution. And therefore, the court developed the doctrine of basic structure. Interestingly, the court did not foreclose what are the basic structure and kept it open. And in subsequent cases, one after the other, we have found that this is a basic structure, rule of law is a basic structure, independence of the judiciary is a basic structure, our federal system is a basic structure, parliamentary democracy is a basic structure, so secularism is a basic structure. So, and this case was, this principle, 13 judges, was subsequently explained in Vaman Rao's case, before that Minerva Mill's case, A.R. Kohler's case, so many cases. Now, at that point of time, certain political developments were also happening in our country. Mrs. Gandhi's election to the parliament from the Raebareli constituency was challenged by the defeated candidate Mr. Raj Narayan on the ground that she had indulged in corrupt practices as defined under the Representation of the People Act 1951. It was heard by a single judge of the Allahabad High Court. Matter went to Supreme Court, up and down, it went on for several years. Ultimately, learned single judge of the Allahabad High Court nullified the election of Mrs. Gandhi on the ground that she had indulged in corrupt practice. What are corrupt practices? We did not go into it. In today's context, perhaps those corrupt practices may not appear to be corrupt practice at all. But we did not go into that aspect. Nonetheless, the court held that this was a corrupt practice and for which her election was nullified. Now, Mrs. Gandhi had to challenge this. And at that point of time, Supreme Court was in summer vacation, right? Just as now, it was in summer vacation. Mrs. Gandhi went to Mr. Palkiwala, the lawyer who had challenged all her decisions till this point of time, and in all these cases, he was representing the other side. She went to him, and he said, "I will take up your case." And he was assisted by Mr. Fadi Nariman while drafting the petition. It was moved before the vacation bench of Justice Krishna. Krishna gave a limited stay. After the whole day matter was heard, and the next day, Justice Krishna gave a limited stay. The petitioner, Mrs. Gandhi, can participate in the proceedings of the parliament, but she would not be entitled to vote, nor she would be entitled to draw any salary, etc. It was thereafter that constitution was once again amended. An amendment was brought in that election to the high offices like president, vice president, prime minister, speaker, etc. could not be challenged by way of an election petition. A separate mechanism would be worked out by the parliament. This amendment was again challenged and it was taken up along with the petition filed by Mrs. Gandhi herself. This is the famous case of Indira Nehru Gandhi versus Raj Narayan. And in that case, Supreme Court struck down this amendments brought to the constitution, saying that this high offices, keeping these high offices outside the purview of a dispute resolution mechanism. That's a very interesting case. More interesting is what followed thereafter. This electoral or judicial setback that Mrs. Gandhi faced led to declaration of the emergency on 25/6/1975. Under 352 article, the emergency was declared. Internal emergency was declared. 2 days thereafter, a presidential order was passed under Article 359, suspending the right to access the courts to enforce Article 14, 21 and 22. Therefore, a political détenu did not have the right to move the High Court for a writ of habeas corpus. That was suspended by this presidential order. This came to be challenged in the MP High Court, Madhya Pradesh High Court, by a journalist called Shukla. He was taken into custody, preventive detention for writing in the newspapers. He challenged it, the detention order of the ADM Jabalpur. It was heard by a bench of Justice Sen. A.M. Sen was, I think, subject to correction, he was there, and Justice Tanka of the MP High Court. MP High Court has set aside this detention and directed that the détenu be set at liberty. ADM Jabalpur thereafter moved the Supreme Court. And this is one of the important cases, though slightly infamous, ADM Jabalpur versus S. Shukla. Bench of 4:1, majority of 4:1, reversed the judgment of the MP High Court, saying that when an internal emergency is in force and there is a presidential order suspending the right to access the courts, you cannot file a writ of habeas corpus. One of the judges who was part of this bench, he posed a question, Justice Khanna, he posed a question to the Attorney General of India, Dhiren Dey, at that point of time. What happens if a person is summarily shot at? Would he have no remedy? He bluntly said no, he will not have any remedy. As long as the emergency is in force and the right to access the court is under suspension. He gave a shocking answer, but Justice Khanna in his memoirs, Neither Thorns Nor Roses, he has commented that somehow it did not elicit the response which ought to have been there. Nonetheless, this judgment was reversing the decision of the MP High Court, and holding that when an emergency is in force, you have no right to move the courts for a writ of habeas corpus. Then, of course, this history, Mrs. Gandhi lifted the emergency, elections were held. In the elections, she got defeated, and a new government came to power. Mrs. Gandhi's daughter-in-law, Menka Gandhi, wanted to travel abroad. But her passport was impounded by the regional passport officer of Delhi. She challenged it in a writ petition before the Supreme Court. heard by 7 judges. And this is the great Maneka Gandhi versus Idiot of India. Many things have been said in this case, argued and by Soli Sorabji. Soli Sorabji's authorized autobiography, this is written by Abhinav Chandrachud. I had the good fortune of going through this. He himself said this is one of his most memorable cases that he had argued in his life. Maneka Gandhi versus Union of India. Several things were said, but the prime thing which we need to know is that in this judgment, Supreme Court said that for Article 21, it is not enough to have a written law. It is not enough to have a procedure prescribed by the law for which life and liberty can be abridged. The earlier view, as we have seen in Gopalan, was that there must be a written law. The law must prescribe a procedure. If these two conditions are complied with, a person can be deprived of his life and liberty. Maneka Gandhi, Supreme Court said no. Both the law and the procedure must be fair, must comply with the principles of natural justice. Principles of natural justice are inherent, embedded in the very scheme of Article 21. Therefore, divorce principles of natural justice. You cannot have a procedure depriving a life and liberty of a person. R.C. Cooper, we have seen that each article cannot be treated as a watertight compartment. They have to be read together. And finally, in Maneka Gandhi, the ghost of A.K. Gopalan was buried, finally buried. So this is the Maneka Gandhi's case. According to me, there are many critics also saying that Maneka Gandhi has opened the floodgates. Post Maneka Gandhi in the late 70s, late 80s, Supreme Court has expanded the scope of Article 21. We have seen a host of judgments, it is not necessary to go into it, dealing with prisons and prisoners, rights of prisoners, dealing with speedy trial, fair trial, legal aid, environmental jurisprudence, public interest litigation, a host of matters were laid down, law laid down by the Supreme Court. Of course, we'll put a cap here. So Maneka Gandhi has completely, so it took almost 3 decades for the decision in A.K. Gopalan to be finally overruled in Maneka Gandhi. As I said, post Maneka Gandhi also there are a host of these matters, elaborating the law of preventive detention on prisoners, prisons, legal aid, environmental jurisprudence, public interest litigation, so on and so forth. Friends, the idea is that today's judgment may not be the final say. That's what I'm saying. Many people were disheartened when the Supreme Court said in 1950 about King A.K. Gopalan. In 1970, after 20 years, a portion of that was overruled. In 1978, entirety of it was overruled. Important judgments are there, like Vishaka judgment dealing with sexual harassment at workplace, holding it to be violative of Article 21, laying down guidelines in the absence of the statutory provision. So many cases have been decided. But I feel that, and according to me, the judgment delivered in 2017 in Puttaswamy's case is another of the great judgments which have been delivered, and the full impact of the judgments we are yet to see. It is a work in progress. Just like Maneka Gandhi opened the floodlights leading to a host of cases, I think Justice retired Puttaswamy versus Union of India, a judgment bench of 9 judges, the lead judgment written by Justice Chandrachud, the present Chief Justice of India, its full impact will be felt in the days and years to come. By this judgment, Supreme Court has held that the right to privacy is an integral part of the very human existence. It is traceable to Article 21, and therefore it is one of the inviolable rights of a person. From this, very many things, very many rights can be traced. The right to bodily integrity, the right of the woman to say no to pregnancy can be traced to this. Reproductive rights, these are rights which are embedded in the right to privacy as held by the Supreme Court. I remember in a division bench of the Bombay High Court, we had a petition. In Bombay High Court, we had a bench which was named as a social justice bench. We had a bench, and Bombay, there had a peculiar kind of litigation. Large number of women used to file petitions, one after the other, saying that because of these circumstances, so and so, I am pregnant, or rather in an advanced stage of pregnancy, I am not in a position to continue with the pregnancy. So, despite the embargo of the Termination Act, Medical Termination Act, please grant us the order to go for medical termination of pregnancy. One such case I remember, we had a woman petitioner who was a domestic help. She already had a child, and she already has filed a case against the husband for domestic violence. And she was pregnant and carrying her pregnancy. Husband said that I am not going to support you, I am not going to pay for this second child, you do whatever you feel. Her existence was hand to mouth. So she filed a petition. The medical report said the pregnancy is normal. There's no reason for termination of pregnancy. There's no medical reason for termination of pregnancy. Then she filed a petition that if the pregnancy is allowed to continue and leads to a childbirth, it will have grave impact on my mental health, and it will cause great hardship to me, and I will not be in a position to maintain the child. So please give permission for termination of pregnancy. We have medical boards already in JJ Hospital in Bombay, and other Pune one hospital was there, GM Hospital. There also the doctor said like that. In their judgment, we have elaborated upon the concept of mental health, and we have said that mental health as a concept is much larger than mental illness. Though mental illness is defined in the Act, but for a ground given is that for termination of pregnancy is that it should cause physical and mental hardship to the patient. So we have said mental hardship is a much larger concept. It is like a genus compared to mental illness, which is a species. And therefore, on that principle, on the ground that continued pregnancy or childbirth will cause irreparable damage, irreparable hardship to the petitioner, we granted her permission to go for medical termination of pregnancy. In the recent Supreme Court judgment, which came in September 2022, an unmarried woman had approached the Delhi High Court seeking permission for medical termination of pregnancy on the ground that her relationship had broken down with the person with whom she was staying. Delhi High Court declined it. Matter went to the Supreme Court. Supreme Court relied upon this Bombay, one of the decisions relied upon was this decision of the Bombay High Court, and said insofar as termination of pregnancy is concerned, no discrimination or no differentiation can be made between a married woman and an unmarried woman. So this is, once again, law has been laid down. All these things, as I am saying, are traceable to this landmark decision in Puttaswamy's case. We will see more about it as we move ahead in the days and years to come. But as we say, there is no finality in law. Today's, whatever we think that the law has attained finality can be reopened again and a new journey can start. Friends, we can go on and on, but thank you for giving me this opportunity, sharing some of my views with you. We are all students of law. Every day is a new day. Every case is a new case. Therefore, it is for us, it is a continuous learning experience. We learn so many things from the arguments put forth by the learned advocates who appear before us. It is their arguments which we build upon and which ultimately transform itself into a judgment. Unless there is a good argument from the lawyer, a judge cannot deliver a good judgment. So, for dispensation of justice, support or cooperation of the lawyers is it goes without saying, this is indispensable. Without the support of the lawyers, the judiciary cannot function. Lawyers are an integral part of the judiciary. Bar and bench must coexist together, must respect each other. There must be mutual reverence between the bar and bench, and then only we will be able to give justice to the litigant public who come before us. With these few words, I thank the organizers for inviting me and giving me this opportunity to share some of my views with you. But before I go, today morning I just took out some extracts of this Puttaswamy judgment, and interestingly, Justice Y.V. Chandrachud was part of the old, part of the bench in ADM Jabalpur's case, and in this Puttaswamy's case, Justice D.Y. Chandrachud has specifically overruled this judgment. I'll just point out this para 136 of A.S. Puttaswamy. I took out the printout today. The judgments rendered by all the 4 judges constituting the majority in ADM Jabalpur are seriously flawed. Life and personal liberty are inalienable to human existence. These rights are, as recognized in Keshavananda Bharati, primordial rights. They constitute rights under natural law. The human element in the life of the individual is integrally founded on the sanctity of life. Dignity is associated with liberty and freedom. No civilized state can contemplate an encroachment upon life and personal liberty without the authority of law. Neither life nor liberty are bounties conferred by the state, nor does the Constitution create those rights. The right to life has existed even before the advent of the Constitution. In recognizing the right, the Constitution does not become the sole repository of the right. It would be preposterous to suggest that a democratic Constitution without a Bill of Rights would leave individuals governed by the state without either the existence of the right to live or the means of enforcement of the right. The right to life being inalienable to each individual, it existed prior to the Constitution and continued in force under Article 372 of the Constitution. Khanna jail was clearly right in holding that the recognition of the right to life and personal liberty under the Constitution does not denude the existence of that right. Apart from it, nor can there be a fatuous assumption that in adopting the Constitution, the people of India surrendered the most precious aspect of human persona, namely life, liberty and freedom to the state, on whose mercy these rights would depend. Such a construct is contrary to the basic foundation of the rule of law, which imposes restraints upon the powers vested in the modern state when it deals with the liberties of the individual. The power of the court to issue a writ of habeas corpus is a precious and undeniable feature of the rule of law. Ultimately, ADM Jabalpur must be and is accordingly overruled. We also overruled the decision in the Union of India and so and so. So this is the judgment in A.S. Puttaswamy. With these words, I once again thank each one of you for giving me appreciation. Thank you.
My Lord the Chief Justice, the Constitution and the role of the judiciary in upholding the Constitution, my Lord the Chief Justice has referred to the various judgments of the Supreme Court. I wish many of them have noted down. Even otherwise, I request every one of you to download these judgments and put in a book form and keep it in your tables, so that every time whenever you comment on an issue, you can look into the judgment, and each paragraph of those judgments will be of actual value in discharge of our functions as well. So everybody please download from the website. Now we have a e-portal in the Supreme Court, ESCR. You can click and get each of the judgments, get download, print it and keep it in your phone. My Lord was referring to Keshavananda Bharati. I recollect this judgment of 13 judges case has been given an immense contribution in the form of debate with various forums. I also that Indian Law School, they conducted a seminar and 13 professors with 13 research students, they undertook the entire trial, how the judgments were delivered by each of the judges.